So I wanted to talk about some general guidance that's provided in reading and interpreting the California Penal Code. This is the equivalent of a criminal code, which is the original name of one of the four first codes in the state of California. Today, California statutes are contained in 29 separate codes. The 19th alphabetically is the Penal Code, and all 29 codes have some general provisions that are applicable to reading and interpreting that code's sections. So the following is some of the general provisions of the Penal Code. Section 1 says that this act is known as the Penal Code of California, and it's divided into four parts. Section 3 says that no part of it is retroactive unless expressly declared. Section 4, the rule of the common law that penal statutes are to be strictly construed has no application to this code. All of its provisions are to be construed according to the fair import of their terms, with a view to effect its objects and to promote justice. Section 5 says that the provisions of this code, insofar as they're substantially the same as existing statutes, must be construed as continuations rather than as new enactments. Section 7 says that words used in this code in the present tense include the future as well as the present. Words in the masculine gender include the feminine and neuter. The singular number includes the plural and the plural the singular. The word person includes a corporation as well as a natural person. The word county includes city and county. Writing includes printing and typewriting. Oath includes affirmation or declaration. Every mode of oral statement under oath or affirmation is embraced by the term testify. Every written one in the term depose. Signature or subscription includes a mark where the person cannot write. Section 8 says that whenever by any of the provisions of the code an intent to defraud is required in order to constitute an offense, that it is sufficient if an intent appears to defraud any person, association, or body, politic, or corporate. Section 9 specifies that the omission to specify or affirm in the Penal Code any liability to damages, penalty, forfeiture, or other remedy imposed by law and allowed to be recovered or enforced in any civil action for any act or omission declared punishable does not affect any right to recover or enforce it. Section 10 of the Penal Code says the omission to specify or affirm any ground of forfeiture of a public office, or other trust or special authority conferred by law or any power conferred by law to impeach, remove, depose, or suspend any public officer or other person holding any trust, appointment, or special authority does not affect the forfeiture or power or any proceeding authorized by law. Section 11 says that the code does not affect any power conferred by law upon any court-martial or other military authority or officer to impose or inflict punishment upon offenders. Section 12 specifies that sections of this code which declare certain crimes to be punishable devolve a duty upon the court authorized to pass sentence to determine and impose the punishment that is prescribed. Section 13 says that whenever in this code the punishment for a crime is left undetermined between certain limits, then the punishment to be inflicted in a particular case must be determined by the court authorized to pass sentence within time limits as may be prescribed by this code. Section 14 says that the various sections of the Penal Code which declare that evidence obtained upon the examination of a person as a witness cannot be received against him or her in any criminal proceeding does not forbid the evidence being proved against the person upon any proceedings found upon a charge of perjury committed in that examination. Section 19.4 says that when an act or omission is declared by a statute to be a public offense and no penalty for the offense is prescribed in any statute, that the act or omission is punishable as a misdemeanor. Section 20 specifies in every crime or public offense there must exist a union or joint operation of act and intent or criminal negligence. Section 21A says that an attempt to commit a crime consists of two elements: a specific intent to commit the crime and a direct but ineffectual act done towards its commission. And finally, Section 24 of the California Penal Code says that this act, whenever cited, enumerated, referred to, or amended, may be designated simply as the Penal Code. And then, of course, you include the number of the particular code section as well.